Supreme Court has set aside the Bombay High Court's order on a POCSO case. That'll be our top focus at this hour. Very good evening. Thanks for joining us here on Mirror Now. I'm Afrida Rahman Ali. So like I said, the top court has set aside the earlier order of the Bombay High Court that ruled that skin-to-skin contact is essential to establish sexual assault. The Supreme Court has now said that the Bombay High Court's order is insensitive as it legitimizes and trivializes behavior that undermines the dignity of a child. The judgment comes after the Nagpur bench of Bombay High Court in January this year had acquitted a man of sexual assault on the grounds that groping over clothing without skin-to-skin contact does not amount to sexual assault under the POCSO Act.
The Supreme Court of India has gone ahead and passed a landmark ruling pertaining to the POCSO Act. The court has stepped in and set aside the earlier January ruling of the Nagpur bench of the Bombay High Court, which had said that skin-to-skin contact is necessary for invoking charges against the POCSO Act. The top court has made some scathing observations saying that the earlier ruling of the Bombay High Court is absurd and the intention of the act has to be safeguarded. It was essentially the Attorney General of India in one rare time who had challenged this order of the Bombay High Court before the top court, and the Attorney General, the top law officer of the Government of India, had also argued before the Apex Court as to how this earlier order of the Bombay High Court was outrageous, and if it was allowed to continue in the same shape and form, it could have repercussions on 43,000 cases which invoke the POCSO across India every year. The top court has frowned upon this order of the Bombay High Court, calling it absurd and calling the Bombay High Court order as completely preposterous, saying that the intention of the act has to be retained. And the Supreme Court also saying that the earlier Bombay High Court ruling trivializes the dignity and the stigma children of a tender age undergo.
All right, joining me here on the broadcast is senior lawyer Karuna Nandi. Karuna, good evening. It's interesting that you had Justice Pushpa Ganadiwala actually saying that groping over clothing can come under outraging the modesty in IPC section 354, but not under POCSO, something that the top court has now overturned. Your thoughts on this development, ma'am?
I think that it was a real problem as a judgment, and it would have affected children potentially all across the country and different kinds of sexual assault, right? And particularly the types of sexual assault that are only punishable under POCSO. For example, there are higher sentences for some types of sexual assault, etc.
Yes.
And the thing that the Bombay High Court judgment said, and this particular judge was on the Nagpur bench, that if there's no skin-to-skin contact, so therefore, and this was noted in the court's judgment, Justice Uday Lalit and Justice and another judge have given two very progressive judgments. And I think the point that was being made was that if you wear a glove and you molest a child, that's okay. And I think, for myself, taking the point further, what if a child is raped and the person is wearing a condom and two gloves? Are you going to say that that's not sexual assault? So the Bombay High Court judgment was so egregious that the Attorney General came in challenge of it. And I thought that was very positive to show that the state will not tolerate this kind of injustice against children. And I hope that steps are taken to ensure, because I think the same judge, the same judge did give a equally problematic second judgment. And I think that steps need to be taken to ensure that all of us, whether we are lawyers or judges, all of us in the legal system have continuing legal education. This is something that is required. I'm qualified in New York, and this is something that is required for lawyers in New York, for example, that you have to keep updating your knowledge and you have to show that you have updated your knowledge.
Yes, the point about intent, Karuna, is being highlighted by, like you said, the bench of justices U.U. Lalit and S. Ravindra Bhatt and Bela Trivedi, saying restricting the meaning of touch to skin would lead to a narrow and absurd interpretation and destroy the intent. So somewhere emphasizing on the intent part of it, Karunanandi, is that what you think is the biggest takeaway from this?
To me, there are two takeaways. One is that when you have an act, you shouldn't do violence to the meaning of the act. You should try and fulfill the purpose of the act, and any interpretation that is in accordance with furthering the constitutional principles of the right to dignity and the right to dignity and the I have a child singing ABCD in the background. The right to dignity and the right to bodily integrity. That is the interpretation that must be furthered, right?
Yes.
But I think the second and an equally important takeaway is this, is that when you have the bench or police officers or, even I think lawyers actually doing sort of acting in ways that are really contrary to that we must address that. I think that at one level, one can look at the administrative powers over judges of the High Court that the Chief Justice has, right?
Yes.
But also continuing legal education through the state judicial academies and the national judicial academies. And I personally think that there should be exams, at the end of these every year or every couple of years to make sure that people are up to speed. And because if you're not upholding the law and if you're not upholding fundamental rights, then you are doing violence to the people that you are meant to serve.
Yes, this act primarily is intention to protect children from sexual offences. So this particular judgment from the top court that clears the air on what constitutes a sexual assault on a child is extremely significant. Thank you so much for joining us with your views on this, Karunanandi. I'm also joined by Bharti Ali, child rights activist, joining us on this subject. Bharti, the fact of the matter is the top court has not just squashed the High Court order, it has also reprimanded that kind of order, which it feels has trivialized the whole issue of child sexual assault by, doing this kind of a hair splitting on what constitutes an assault and putting it under IPC rather than under POCSO. Where do you stand on the issue, Bharti?
Well, as far as, this particular case is concerned, one was looking forward to a judgment like this. And I'm glad the Supreme Court has reiterated, the importance of sticking to the import of law, to looking at the larger picture and what our children go through and not, taking a it wasn't even a very technical approach. I don't know where that was coming from. But otherwise, judges do tend to take a very, very technical approach at times in interpreting laws.
Yes.
And so therefore, what the Supreme Court has done is really, really welcome. But, there is another side to it. And I really wished the Supreme Court had looked at that as well. This is not the first case of its kind. We have seen lots of cases where the special courts are, desperately at times trying to give certain interpretations, especially in cases of consensual sex between, young people, between adolescents, where they don't necessarily want to punish, the accused because they see it's a consenting relationship. Often enough, the girls and boys are married, and there are also cases where the girls are pregnant due to the relationship. Whereas the law is so strict now that it makes out a statutory offense to have any sexual activity with somebody who's under the age of 18 years, and reporting is mandatory. The sentences, some minimum mandatory sentences have been prescribed, taking the discretion away from the judges. So that forces them to look for different ways on, trying to be a little lenient in such cases. So I wish that aspect had also been addressed somewhere. I'm not specifically referring to this case, but generally we've seen lots of cases. Now, the same definition of assault as given in the IPC has been used in one case by a judge from the special court, a former judge of the special court in Delhi, in a case of a consensual sexual relationship, saying that assault implies force or, some preparation, whereas in the case beforehand, the two seemed to be in consenting relationship and there was no force. And therefore, he's used that definition of assault in the IPC to actually acquit the accused. So that's why I'm saying.
But
that,
if I'm not mistaken, Bharti Ali, when it comes to child sexual abuse or child sexual offences, the whole the term of consent doesn't even apply. The consent part of it is not even relevant, at least in this case. Am I right in that?
Which is true. That's why we are saying that, this is time now to think about having an age of consent and recognizing that there are young people who are engaging in sexual activity, and the law, which is meant to protect them, should not lead to increased criminalization. People make choices. They could be right choices, wrong choices. But if the law is going to criminalize them for their choices, then the objective of protection somewhere is lost. So we've got to, have a balance. And we've got to look at child rights holistically and child protection holistically. So while we want to protect everyone under 18 who's forced into sex, we also need to look at certain realities and address those realities to ensure that we don't criminalize young people.
Right.
So there's with law, we need a lot of education as well, around sexuality and sexuality.
In fact, that's what
rights.
Karuna Nandi was also emphasizing, that it's important to keep abreast of the, the important updates that come in these regards from various judgments across the country. I would just quote from what the Supreme Court has said, that courts should not be overzealous in searching for ambiguity in words that are plain. The Supreme Court said narrow pedantic interpretation that would defeat the purpose of the provisions cannot be allowed. So do you agree, Bharti Ali, very quickly, that it was a rather narrow interpretation that led to this kind of an order from the Bombay High Court earlier?
Definitely. The law talks about physical contact. It doesn't have to be a skin-to-skin contact to make out a case of sexual assault.
Yes.
And the sexual intent is what is most important, which the Supreme Court has reiterated. So I completely agree with this, with the judgment.
Okay.
We do need to be very, very conscious, especially the trial courts have to be very conscious about how they are interpreting laws and to what end. The larger good should not be lost.
Yes, absolutely. And on that, on that note, thank you so much, Bharti Ali. The larger message, the larger intention should not be lost. The larger intention of the POCSO Act is to protect children from sexual offences. Thanks very much for joining us.